ऑफ कर दो जरूरी नहीं। यस
May I please, Your Lordship, I'm mentioning, Your Lordship, one item, WPC 311/2025. On 16/12/2025, Your Lordship, by this Honorable Court, order was passed fixing the date on 22nd December 2025. Instead of that, here in the order, it has been reflected inadvertently, 22nd January 2025, Your Lordship. So that,
it should have been 22nd 12.
yes, Your Lordship.
No idea.
Yes, Your Lordship, it's
Is it urgent?
January 2025 is also
What?
correct, Your Lordship.
January 2025 is holiday.
January 2026, it would not have.
26 also holiday.
No, let it be on 22nd December 2025.
22nd December.
Yes.
Today is. I have no idea. Okay. Okay.
I've anything. Order also in the Lordship.
Hmm?
Order also have. For that correction only.
Correction. When do you want this?
On 22nd, it
Okay.
was fixed.
Today you want, it was fixed on 22.
Yes.
Inadvertently, it is mentioned as 25 January.
22nd January 25, yes.
Okay, 22nd January. 22nd January is. Let it be on 22nd January. What's the problem? What urgency is there?
Lordship, kindly peruse the order also I have given.
It should be 26. Yes,
It should
for
be,
correction.
it should be
26.
22nd
2026.
December, Lordship, December 2025.
Hmm?
22nd December 2025. It was fixed on that day.
Instead of
Inadvertently, it has
January.
been- Yes, Your Lordship.
What is this matter about?
This is regarding suspension, Your Lordship. He is already under suspension for almost 2 years. There is some urgencies there.
Okay, that's it.
Much of my Lordship.
Your Lordship, may I mention item number 2?
Yes.
Yes. As the main arguing counsel, Mr. R. Sunari is out of station. So I pray that this matter may be listed after ensuing vacation. I
Mr.
for petitioner M. Khambo.
Land Council 4. The Land Council submits that the conducting council, Mr. Rajesh Sonar, is out of station. Therefore, pray for adjournment of the matter to be listed after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Such.
Lordship, I would like to mention item number 7. Here we have to file affidavit, Your Lordship. Some time may be given, Your Lordship.
Which one?
7, item 7. I've taken the consent, Your Lordship.
Ms. Prasad, Land Government Advocate. For the state respondent. Prays for father. How much time is
3 weeks, Your Lordship.
Father? 3 weeks. Time to file affidavit in opposition on behalf of the state respondent. She has also obtained consent from the Land Council of the petitioner. The prayer is allowed. List this matter after 3 weeks.
Obliged, Your Lordship.
My lord, I beg to mention item number 3. My lord, the conducting council is out of station.
This matter otherwise is ready for hearing. Can it be listed for hearing? Pleadings are complete, it appears.
Okay.
Is it? Item 3, pleadings are complete, it
Yes, Your
appears.
Lordship. Reading are complete, Your Lordship.
Okay. Miss,
Ajiva, sir.
Land Council for the petitioner. Also, Ms. Pango, Land Government Advocate for the state respondent. Staff. It is submitted that the pleadings are complete and the matter is ready for hearing. So, in view of the above, let this matter be listed for hearing after 4 weeks. Okay.
Obliged, Your Lordship.
There is an engineer.
The interim order passed earlier shall continue till the next date of listing. Okay.
May I, Lordship?
Yes.
Lordship, on behalf of the Standing Council Education, T. Tagum, I beg to mention item number 4, 5, and 8.
May, Your Honor, in item number 4, I am the petitioner.
Okay, in item 4, you have noticed Education Department has notified affidavit.
Yes.
Mr.
L.
You are Mr.
L. Theta.
Land Council appearing on behalf of Mr. P. Togum, Land Standing Council for the Education Department, pray for further 3 weeks time to file affidavit in opposition. The prayer not being objected to by
Right.
the Land Council for the petitioner is allowed. List this matter after 3 weeks.
Your Honor, in this item number 4, as per the last order, it is already given a last opportunity to file affidavit.
Let them file. Okay. 4 and item
5 and 8.
5 also. 5, 5 I think is ready for hearing.
For the petitioner.
In 5?
Yes.
5 I think is ready for hearing.
Yes.
Pleading completed.
Yes.
Okay. Mr. D. Kamdi, Land
So,
Council for the petitioner.
May I
Will
have
be
a
listed for
statement
hearing.
On 21st of January.
Okay. Also had Ms. Pango, Land Government Advocate, appearing on behalf of the state respondent staff. We submitted that the pleadings are complete and the matter is ready for hearing. So in view of the above, let this matter be listed for hearing.
On 21st
Yeah.
January.
And age grade for come listed on 21st
January.
January for hearing. Okay.
Much obliged.
Item number 8.
Item 8. Yes, in 8. What is to be done?
On previous day, petitioners were to file affidavit in reply. We have filed our affidavit in opposition though. However, the standing council is
Okay. Who is out of station?
the standing council for the education.
Okay, who is for the petitioner?
Petitioner is R. Koi.
Har koi is present. Have you informed?
Yes, we.
Okay, Mr.
L. Theta.
So you are praying for, okay, Land Council appear, you are appearing on behalf of Mr.
Titago.
Titagam, Land Standing Council for the Health Department with the consent of the Land Council for the petitioner. Praise for listing this matter after 3 weeks.
Unposted.
Okay. Mr. Jitaro, Land Government Advocate. You are as a government, it's a WPC, you are government advocate here.
Yes.
It's
No,
not
no.
surprised. Item 8.
RMF.
Item 8 is WPC only, writ petition.
No,
Where is-
WPC is there, but criminal element is also there.
Okay. Land additional PP is also present. Let's pray for Kama list this matter after 3 weeks. Okay.
Item number 1.
May I please,
Yes.
this is the third round of litigation, my lord.
Third round of litigation.
My lord.
What happened to the first, second?
First one, my lord, the facts, my lord, here is that in Anjao district, my lord,
Hmm.
petitioners, they are in possession of a certain plot of land, a certain area, my lord. It's an ancestral area. Now, in that ancestral area, in the year 1979, the private respondents, man, of course, they belong to the same clan, but otherwise from different villages, man. Now, these private respondents were allowed for few years with the permission of the petitioners, man. They cultivated some land, man. Now, after that, 4 or 5 years, they left and they permanently settled in now in Lohit district, man, under Wakro village, man, in Lohit district. Now, in the year 2011, man, there was a proposal for a Demwe hydroelectric project, man. Now, when that hydroelectric project was, the survey started, that these private respondents, they came and started claiming over that area also. The forest, under the forest. So a Gram Sabha meeting was held, man. And the forest rights, man, between the petitioners and the private respondents were heard, man. Now, in that Gram Sabha, man, the forest rights were given to the private respondents. Of course, they are since even though if they are no longer residing there, man, the my lord knows under the Forest Rights Act, man, it has to be the person who is in occupation of the land. Now, against that appeal was preferred, my lord, in the sub-divisional level committee, my lord, before the ADC Hailyang. ADC Hailyang, my lord, without properly hearing the parties, petitioners, my lord, dispose the matter. Now against that, again, an appeal was preferred before the DC, man. DC also did
Second appeal.
under the provision only that Scheduled Tribe Forest Rights Act, man, for that act only, 2006 Act, man.
Okay.
Now the DC also disposed the appeal in a mechanical manner. Now then the petitioners approached the Honorable Court by filing WPC 273 of 2012. Man.
Okay.
Now in that, the WPC 273 was disposed, my lord, on 18/7, my lord,
Hmm.
with the direction to the Deputy Commissioner to give proper hearing to the petitioners before passing any order.
Hmm.
Now the DC, instead of complying with that order, transferred it back to, remanded it back to the ADC, man. Now the ADC says, since the direction is against the order of the DC, you decide. Now the DC again passes a similar order. Nothing, man. That order, my lord, I will take your lordship to page 59, man. Since there was a direction from this court, man, Honorable Court, saying that you reconsider after giving the parties the opportunity. But the DC places it back before the subdivisional level committee, and the subdivisional level committee places it back to the DC, man, saying that it is for your consideration. At page 59, man, this is the order, man. In compliance with the Honorable Guwahati High Court so and so, Nahala in connection with WPC so and so, the matter was endorsed to appropriate committee, that is subdivisional level. The subdivisional level committee held its sitting on 9/1/2012 at Hailiang. Before that, just may I take your notice to page 58, man. Second last paragraph, man, just the operative portion I will read.
Hmm.
What the subdivisional level committee said. Sri so and so, on behalf of Kajing Tayang, expressed that this review meeting SDLC should have been conducted at DLC, that is district level committee, headed by the DC. DLC level, as the SDLC had already pronounced judgment in favor of Kajing Tayang, and the order of Honorable Court is against the judgment of DLC, not the SDLC. Kajing Tayang did not put any other points so and so, so and so. So with the above minutes of the review meeting of SDLC dated 1 night so and so regarding ownership of 16.5 hectares of land at Kajing area has been placed before DC come Chairman DLC Hawaii as directed by order on the body of the petition of so and so, so and so. So he's only placed it back, nothing, no decision, because that was before. Now the DC passes it order. In compliance with the direction of the Honorable Guwahati High Court so and so, the matter was endorsed to appropriate committee, that is subdivisional level committee Hailiang. The subdivisional committee level held its sitting on 1/9/2012 at Hailiang. The resolution of the Gram Sabha held on so and so, which was later upheld by the subdivisional level committee by its decision of dated so and so, and subsequent decision of district level committee on so and so is upheld. The decision of the SDLC is accepted. Copies of the decision. This was again passed, man. In fact, the decision of the district level committee 28/5/2012 that was set aside, man, by this Honorable Court.
Hmm.
The second paragraph, my lord, page 59.
Which was set aside.
And subsequent decision of district level committee on 28/5/2012 is upheld, man. It
Yes.
was against this order. Now, no, madam. Page 60, madam. CRP 7 of 2013. Now this here on 11/4/2013, the notice was issued, and in that interim was granted, madam. That is, it is at page 64, madam. In view of the above and considering the entire aspect of the matter, it is hereby directed that the status quo as on today, with regard to the possession of the disputed land and its title, be maintained till returnable date. List the matter so and so. So status quo with regards to the possession was given, and the petitioners, they continued with the possession, since they were already in possession of the land. Now, all this while, my lord, and after that, this was pending my lord, for a long time, this CRP, my lord. Now, surprisingly, my lord, at page 65, my lord, Annexure 9. The fact remains that all along the petitioners are in possession of the land. Page 65, my lord.
Yeah.
A complaint has been, an order was issued by the additional deputy commissioner. Type copy would be at page 66, my lord.
It's clear only.
Yes, ma'am. There he has passed some order directing the petitioners to stop all activities, man. Because from the order, it seems there was a complaint by the private respondent saying that the petitioners have illegally encroached and occupied the land. And this has now come up because that hydroelectric project, man. It was earlier, after that, all this process.
Now, what happened to the death petition after interim order? It was dismissed.
Yes, no, my lord, it was subsequently, not the writ petition, CRP, man.
Sorry, CRP.
Yes, my lord. That order is at, my lord, page 60, man. Oh, sorry, not 60, my lord. Page 67, man. 69, man. Page 69. Of course, that order was, that CRP was also dismissed, my lord. That in the absence of the counsel for the petitioners. So the petitioners were also not aware, man. This was in 13/11/2019. Page 69, Annex 11, man. And the order is at page 71. 13/11/2013, man. None appears.
Saying that civil revision doesn't maintain, is
Yes,
not
under the
maintainable.
CRP, it is not maintainable, man.
Then
Yes.
what happened? Have you challenged this?
No, this does not, my lord, affect, otherwise affect the merit, my lord. Now, my lord, after this, my lord, we were
No,
not
no.
aware.
How it does not affect the merit of the case? Because your civil revision was dismissed.
Yes, my lord. So nothing has been decided.
Then the land belongs to the respondent unless you challenge
No, my lord. That
the
I have,
decision,
that I have
district
put
level.
to- that I have put to challenge here also, my
Where?
lord. In this writ petition also, my lord.
No. After that,
Yes, ma'am.
after dismissal of the civil revision petition,
No, my lord. That's why, my lord, I will take your lordship to the first line order of the order itself, my lord, on page 71, my lord.
yes.
None appears on behalf of the petitioners, ma'am. So since the petitioners were not represented, the petitioner was also not aware of this subsequent development.
Okay. But then it was dismissed.
Dismissed, man.
Now you know.
Now, no, I know, we
Okay.
know.
Then what did you do?
That's
after
why,
knowing?
my lord, we are here, man. That's why today we are here, man. And other than that, we are challenging the subsequent orders passed by this by the ADC, man. By the ADC highly, man. Because if my lord will come to, my lord, we have procured the complaints, my lord, at page 72, my lord. Page 72, my lord, is there, man.
Yes.
This is before the additional deputy commissioner, so and so, man. Is the party's name, and then page 73, my lord. In the matter of a petition and filed under section 164 of BNSS for illegal occupation and encroachment of the land by the aforesaid respondents at the land belonging to the petitioners located at Kajing area under so and so, man. So, my lord knows this under 164 of BNSS. It is corresponding to the earlier section 145, man. And this under these provisions, man, section 145, man, the only this extraordinary power has been given to the executive magistrate only for maintaining the public order and tranquility. That is my basic case here, man. Because if a dispute as such, man, this is civil in nature, man. He has no authority.
Yes, but see, after
Man.
dismissal of your civil revision, the land is supposed to be.
No, man, we continued the possession, man.
No, why should you? Because it was decided in favor of the respondent. You are not supposed to possess.
No, my lord.
the land unless you challenge.
Yes, my lord. Of course, that is another aspect which I have also put to
So
challenge
this,
here.
this was an encroachment only.
Not encroachment, my lord. We have always been in possession, my lord.
No, the subdivision, you said that Gram Sabha meeting
Yes, ma'am.
decided in your, against you.
Against us.
Subdivision also decided against you. And then in appeal also, the DC upheld, and then it was also against you. 3 level against you. And then you filed civil revision, that also dismissed.
Dismissed, my lord.
It is supposed to be with the respondent only, not with you.
No, my lord. That is the issue, my lord. It is not, my lord. Here because we have always been in possession, man. And by virtue of the CRPs, their interim orders passed in we have continued in the position. We have always been in position. Now, the only issue, the petition, the private respondents,
Now,
They-
my query
my lord,
is that it was decided way back in the year 2011, 12.
12, my lord, 2012,
It's
but
not supposed to be
no, my lord,
in your possession.
my lord, that's why I
Now we are in
took your lordship
2025.
I took lordship to the order of this honorable court in page 60, my lord.
What is basic?
That's what I was trying to. For that, my lord, even if assuming, my lord, that is another procedure, my lord.
No.
That's page 60, my lord.
60, page
Page
60.
60 and relevant portion, my lord.
No, this you have already challenged this one
Yes, my lord.
by way of, by filing
page
civil revision.
60
Civil revision dismissed.
Page 60 is the order passed by this honorable court, my lord. There's an interim order, my lord. That's what I
Page 60.
60.
No, interim order thereafter subsequently
Well,
dismissed.
Yes,
And
my
then-
subsequently,
and the interim order pass also stand dismissed.
what I am trying to, my lord,
No, no,
im-
you
impress upon is that,
first try to
my
understand.
lord,
Number one,
Right.
at 3 level, it was decided against you.
my lord,
High Court, although passed status quo order,
Well.
but then subsequently it was dismissed,
my lord,
and the status quo order also dismissed.
my lord. Of course, it's
That is the position. now.
yes, my lord.
Okay. Thereafter, what right do you have? My query is.
No, my lord.
Hmm.
What my right as such is totally different thing.
Hmm.
What I have challenged here in the petition, my lord. I have also put to challenge those
Now,
orders
see.
also, my lord.
See, after this, this land is supposed to be with the respondent.
No, my
Assume-
lord. We are in possession, my lord. We
You are not
still
supposed to be unless you challenge.
supposed to be, my lord. Whether I'm supposed to be or not, my lord. That is another aspect, my lord.
Okay.
But I have continued to be in the position, my lord. And the petitioner,
Whatever may be, but the decision is, the order, all these orders are in their favor of.
of course, it is in
Why you are under possession still?
my lord, because they have also never come and claimed, my lord.
Is it
Because-
possible?
Yes, man. Now, my lord, what happened, my lord? What I was subsequent development, my lord, what happened? During all those meetings, my lord,
Mhm.
Gram Sabha meeting, DLC meeting, at that time, the hydropower project was there, supposed to be there. But what happened, my lord? That private company, Athena, my lord, it went bankrupt, my lord. So the project did not commence.
Who was bankrupt?
The
The
private
project.
company that was supposed to develop the hydroelectric project.
Okay.
Not that hydroelectric project, that developer, my lord, went
Ah.
bankrupt. So nothing happened after that, man.
Okay.
So their petitioners also, or the private respondents also were not interested, man. My lord, you see, this is all about the compensation of the land. The private respondents want the company. Now there is a rumor that it will be revived again. So that's why now the petitioner or private respondents have come up again, my lord. Because all is well, they were also not interested, man. Because they don't reside there. Man. And if you also would see the complaint also, my lord.
See, that we since aforementioned decision, we have been enjoying peaceful possession and enjoyment of our land without any claim or objection. See, this is there in the complaint, in accordance with the order passed by the district level committee.
That is, my lord, will see that is contradictory to the orders passed by this honorable court, my lord.
This
This
court
honorable
passed.
court has always passed order
Hmm.
in the WPC, then subsequently in the second part, litigation, my CRP also, status quo of the possession.
Now, status quo dismissed.
Dismissed, my lord. So
Then it
when
is
we
under
say,
their possession thereafter.
when we say, my lord, when the petitioners say that since aforementioned, because they are saying that 2011, since then we are having possession, my lord. That is totally wrong. But,
See,
we are not going today, my lord, into,
against the order. What you
My
are
lord,
submitting is
before
against
this-
the order. All these order against you.
I admit, my lord. I
Yes.
admit, my lord. I admit that is against me, my lord.
From this, you see 1, 2, 3, and then 4 High Court.
Well-
High Court, on the High Court last order, thereby you have been eliminated.
No, my lord,
It appears. They are also saying that thereafter it was under their possession,
no, my lord.
and you are
That
now
is-
encroacher,
No, my lord, that is another,
new encroacher.
oh, my lord, that is why I.
If you are claiming the earlier one, then you should have filed title suit or whatever.
No, they,
Hmm.
my lord, that is why, that issue is still alive, my lord, that I have.
How
raised
it is alive? Have you
That-
challenged the order passed against you?
No, my lord, that issues I have also put into challenge in this writ petition also. my lord.
Again,
My lord. Again, my lord.
what about the dismissal order?
Dismissal order, my lord, it doesn't say anything, my lord. It doesn't go into the merit, so it doesn't have any bearing on the merit of the case, my lord.
No, then the merit was decided by the district level, subdivision, district,
The
and at
manner-
Gram also.
this
Three
one-
level, they have decided the title
My lord, that's why I have said if your lordship would come,
as for the Forest
then
Act.
I will take your lordship to page 52, my lord, of the first order passed by this honorable court.
See, those order,
No, my lord, that's why, my lord. At this stage, my lord, what I'm saying, man,
hmm,
whether I'm in possession, they are in possession, that is also another aspect, man. That is all disputed facts, man. But what was the ingredients, my lord? What was the necessity of the executive magistrate passing an order under section 164 of the BNSS? Whether those ingredients or the necessity for initiating and proceeding under section 164, my lord, that has been complied with or not? That is basically my case at this stage, my lord.
now see the first, prima facie it appears that it was under their possession only.
No, my lord.
Now you are encroacher.
No, my lord, that's what I'm saying, my lord. This is a disputed issue whether I am in possession, that is they are because they have stated they have annexed. If
See,
your
the
lordship would-
title, the documents till now
No, no,
shows that it is under their possession only. They have a title.
no, my lord. That what I'm showing is that in fact it is in my possession because of the viability
Now,
of this.
it was illegal. See, 3
Illegal-
order plus High Court order, 2 order, 5 order against you only.
The High Court order is not against me, man.
The dismissal is in whose favor then?
Dismissal, it doesn't say anything. It only says
It will not say, but then have you,
Okay.
thereafter what happened? Thereafter what happened? If you did not do anything, that the earlier order stand.
no. There is. That's why I'm putting those to challenge, my lord. And then, my lord, I will take your lordship to the complaint again, my lord.
Now you are challenging the 2011 order.
Those orders as well as this 2025 order also, man.
2011 order also you are challenging now after
Yes.
15 years.
I'm putting to challenge, my lord. That is another aspect. Your lordship would look into it at the time of the hearing, my lord. But at this stage, for this motion stage, my lord, if your lordship would to come to page,
They are also raising res judicata.
there's no rest judicata, my lord. If your
If
lord,
you are claiming again,
no, my lord,
then what is this? What is it? If you are claiming again without challenging the earlier order passed by the
my
Gram
lord, I have always put to
subdivision and
challenge. I
district.
have always put those orders to challenge, my lord. Unfortunately, my lord knows, my lord, the CRP was dismissed, my lord. That I also admit, my lord.
Mhm.
But that I have also stated in my petitioners, we are not aware of that because the petitioner counsel was not present there, my lord, on that day, my lord, when that matter was dismissed, man. And it's a settled law, my lord. That for the mistake of the council, man, we cannot be made to suffer, man. We are not aware. We only came to learn about it only when these matters were now complaints were lodged, man.
Is it a for restoration? No.
No, my lord. At this, my lord.
No,
It
was
is
dismissed.
only under the section 164, my lord. My lord knows 164 VNSS, man, is corresponding to 145, my lord. And there are situations when that order under 145 CRPC or
If it is
my lord.
with regards to the same plot of land, same disputed land, then automatically the title and the possession, the record shows that it is with them.
No, my lord. My lord will say, that's why my lord will come to page 84, my lord.
See,
This is part of their complaint, my
after sleeping over,
No,
the matter for again and again, and then even after decision of a 5, 3, 4, 5 court decided, the forum decided against you, and now also you say that it is under your possession,
yes, my lord.
and then you say
Because
this
my
is-
lord, that, my lord,
this-
because my lord, that,
then what is the order? What would be the value of the order passed by this court?
no, your
Next
lordship,
time-
this
next time
order
you
has
say,
to,
even if this order pass order
no,
against you, then you say come up,
this honorable
still under
court,
my possession.
no, my lord, this honorable court never said this is there or there.
See,
My,
the
my
court,
lord,
whatever rightly or wrongly, if the court has passed some order, unless that court, that order goes,
Right.
it will be difficult. You have to challenge that order which is affecting your right.
no, my lord, this, dismissal of
Now,
the,
time and again,
my lord,
even after, immediately after, now I dismissed,
Right.
saying that you have to vacate, supposing, assuming, supposing, and then thereafter you did not do. Neither you challenge the order. And tomorrow you come again and says that still I'm in possession. How long the court will pass order?
no, my lord, in the CRP, it has only been, dismissed.
That is
because
true, that is true.
not
That is true, I
maintainable under the,
understand.
under
That
the
is true. This is
AFR,
the
my lord.
shelter of the
Yes,
CRPC. Okay. So CRPC, of course, here, rightly or wrongly, they have passed because you are still claiming coming again.
Right.
They are naturally because they cannot take the law into hand,
no, my
cannot
lord.
remove you unceremoniously or without passing any order. That's why they had to pass order.
That's what I'm
Now you
saying.
are challenging here again, saying that it is under your possession.
Yes, my lord.
How long the court will pass order?
No, my lord, my lord, just before passing it, I will take your lordship to the law, my lord.
Hmm.
I will take your lordship page 84 of this writ petition, my lord. This is a part of their complaint, my lord.
84.
84, my lord.
84 is the house.
84 is my house, my lord. This is the complaint they have made, my lord,
Hmm.
against me, against us, my lord. Now we are renovating this house, my lord. This is part of their complaint, my lord.
See, that is what I'm
Well-
saying. Despite of passing order, if you try to establish your right again and again,
My lord. While-
neglecting the order passed by the court without challenging the court's order, and then filing again and again repeatedly, waiting for some order passed in your favor.
No, my lord. My lord,
It will be difficult for the court.
no, my lord. This court, the DLC, my lord, DC as such is not a court as such, my lord. What?
No. See, DC is not a court, but then they have passed this order under Forest Act.
Forest Act, my lord.
Yes.
That is why,
And
my lord, the issue.
under Forest Act, they have a right.
Forest
they have
Rights Act, my
authority.
lord. That is what we are challenging, my lord. Because from their complaint itself, my lord.
Hmm.
Complaint says, my lord, if once again your lordship would come there, my lord. At page 72, my lord.
Yes.
My case before the DLC is, of course, that if your lordship is before so and so, 1 and 2, say so and so, then if lordship was a present second line paragraph, second serial number 2 of their address, my lord. Present address, Old Pukri Village, POPS, Wakro, Lohit District, Arunachal Pradesh, man. Now that is what the one of contents. Another issue is that under the Forest Rights Act, my lord, only a total maximum area of 4 hectares can be granted, whereas they have been given 16 hectares. And the Forest Rights Act also says it has to be under the persons who are in occupation, man. These persons, they are also admitting they have settled there in Wakro, my lord. In another,
Take this point
Well-
and file appropriate application before the appropriate forum. But so long as this order,
that's why, my lord,
remain,
I have
will
come
be
there,
difficult.
come today before this one. Now,
Hmm.
these all issues will be decided later, my lord.
Hmm.
The immediate issue is the order passed by the executive magistrate for my eviction, my lord. Whether that can be done, that is the issue that your lordship would be here today, my lord.
okay, let them come.
Yes, my lord. No, my lord, I will just,
Hmm.
because I am an interim prayer,
Who is,
because in-
state, have you implemented the state also?
state, yes, state is mentioned also in the
Hmm.
post list also, my lord.
It will be difficult
No, my lord, just, I will
because
just-
this apparently it appears that the court order has, the authorities order has
no, my lord, I will
not
just-
been complied with.
Authorities order, my lord.
And then you're taking advantage of the loopholes
No, my lord.
and then the time gap. It will be difficult to pass order again and again.
No, my lord. I'll just, on the aspect of, my lord, this 145, my lord, I'll just rely on.
Who is representing the state? No one.
These issues, my lord.
That is true. That is true. What you are saying is correct. The ADC doesn't have,
My lord.
cannot declare, but then it was already declared.
No, no, not
You are
declared.
not supposed to
Declared.
come again.
No, my lord.
What I'm saying is, otherwise the order per se is of course not in accordance with the provisions of the CRP.
Yes, my lord. That is my issue, my lord.
Hmm.
So today, my lord.
But then you see, you are doing repeatedly. What I'm saying is, you are not supposed to come again there unless you challenge the earlier order.
No, my lord, I have always been there.
Hmm.
Those issues, my lord, will keep aside, set aside for a moment, my lord.
Hmm.
Keep it aside, my lord. Who is in title, who has the title or not, my lord? That this writ petition will decide whether I, whether the
No,
when I put to
see,
challenge,
what I'm saying is for you only.
my lord,
In the later stage also, whatever, even if this AD's order
my lord,
goes also,
my lord.
but then title is against you. So you, unless you challenge, it will be futile effort, what I'm saying. Unless you challenge those orders.
I put those to challenge also here, my lord, in this writ
Hmm.
petition also, my lord. I put those to challenge, my lord,
Because ADC's order,
my lord.
of course, apparently, ADC, if he says something more than what is required to be passed,
ADC's order, my lord, under
Hmm.
section 140, my lord knows, my lord.
because they're under section 145 earlier, now 164.
164, my lord.
He has a limited power.
Power, my lord. And to initiate that,
He cannot decide.
not
He
this.
cannot give like a direction to stop all the, just a minute, not that one. Where is the order?
Order is at, my lord, page 65, my lord. Two orders, my lord, 65 and 67, my lord.
And then he cannot direct to comply with the, or to lose FIR or something. Where was that?
65, my lord, page 65, and then
65.
subsequently in 67 also, my lord. Here they have even directed the OCPS, my
Yeah,
lord. Yeah,
that he can't.
my lord.
He cannot.
At this stage, my lord, I'm only harping on that only. My lord. Because whether my writ petition is maintainable or not, my lord, whether I can put those orders to challenge, my lord. Here, my lord. The orders are,
P.S.
those-
Hailiang
yes,
is directed to carry out verification on the complaint made. That is correct. Implement the decision will not be possible.
because, my lord, the police have come, my lord, and they have said that they will evict us.
Because this direction he cannot.
My lord, that is today what I am urging on, my lord.
But what I am saying is because entire records is against you, are against you.
No, my lord, wait, that's why, my lord.
Gram,
My lord will
subdivision,
decide those issues,
division level, and then the High Court also against you.
my lord.
And then thereafter also, you are claiming and you are encroaching again and again. And then this ADC doesn't have probably thought that this person is coming again and again. This kind of a direction is necessary. Probably must have given.
That, my lord knows, my lord, when the law provides for a procedure to be done, it is to be done in accordingly only, my lord. Not like this, my lord. So that's why, my lord, I'll just relying on the manner, my lord. When those proceeding under 164 or BNSS or 145 CRPC can be taken up, that is
This
only
order, of course, is you're correct. This order is not the correct proper order. Mr. Soki, D. Soki, Land Council for the petition.
May I just read, take your lordship to just one judgment of this our whole court, man.
Just a minute. Huh? By filing this writ petition, under Article 226 of the Constitution of India, the petitioner has put to challenge the following orders. One, huh? I, huh? Order dated 26/12/2012, passed by the Deputy Commissioner, District Level Committee, Anjo. This was passed under what, Anjo? Next, two, huh? Order dated 14/7/2025, passed by the Additional Deputy Commissioner, Hauliang Anjo District. Number three. Order dated 14/10/2025, passed by the Deputy Commissioner, District Level Committee, Anjo District. Four, huh? Okay, this is last order. Number three is last order. Order passed in under 145.
Yes, my lord. Two orders, my lord. One is 14/7 and then second is
Okay,
14/10.
25. Okay, okay.
Two orders, my lord.
Okay. Just a minute. And then, 14/7.
14/7 is, my lord, at page 65, my lord.
This is order passed by.
By the ADC, my lord, under section 164 BNSS, my
Okay. Then in two, huh? Order dated 14/7/2025, passed by the Additional Deputy Commissioner Hauliang, whereby the whereby it was directed to stop all illegal activities at Kazin area of Dowamna village, Hauliang circle, and to strictly comply with the decision of the district level committee, within bracket DLC, and the order dated last one 14/10/2025, huh? Third one would be, by which whereby it was directed to carry out ground verification. No, whereby it was directed the officer in charge, PS Hauliang, to carry out a ground verification on the complaint and to implement the decision of the district level committee, within bracket DLC, order dated 14/7/2025.
DLC slash, man. It's just
DLC slash.
slash the
Okay, order
order
dated
dated.
14/7/2025. Passed by the ADC. Stop. It is some para, it is submitted that the ADC while exercising the power under section 164 of BNSS and it is submitted that it is submitted, that what did you say? What do you want to show here?
Well, there, of course, I've given two judgment, man, but just I will rely on one
Hmm.
Supreme Court and then our High Court. Paragraphs 8, 9, and 10, my lord. And I will read 10 only, my lord. 8 and 9 also, it says the same thing, my lord.
Which one? Sir?
2007 SEC Online Guwahati 93, my lord.
Para?
Para 10, my lord. It starts at 8, my lord. How it's to be done, section 145. But I will just read para 10, my lord.
Hmm.
The provisions contained in subsection 1 of section 145 so that the source of information for the purpose of drawing a proceeding under subsection 1 of section 145 is not material. What is material that the executive magistrate must feel satisfied about existence of a dispute as envisaged in section
No
145.
longer dispute. Here is the case, no?
My lord,
Okay. What I'm saying.
145
Because
and
the title, you yourself has annexed all those documents which
My-
shows that title is with there.
my lord, but
Yes.
145 it's about possession, my lord.
Hmm.
This apart, the dispute must
And
relate
then
to
the
any,
history of this, this case, you yourself has shows
my lord.
that it is not under possession at the moment.
No, it's my under my possession because from the complaint also my lord has seen, my lord. It is their complaint where they've annexed the photograph of my house, my lord. Dilapidated house, my lord, which trying. This apart, my lord, this dispute must relate to any land, water, or boundary thereof, and the dispute must be such which is likely to cause breach of the peace. The expression breach of the peace does not really mean
Not that.
mental peace of the parties
No,
concerned.
no.
Disturbance of public. Para
Where
2007.
have you said that under the 161, the, where is, see.
Now it is 164 BNSS.
Yes, 164, 145, 164. So where have you stated that it is a preventive, 164 is a preventive in nature?
In
And
the
then-
petition, my lord.
Yes, in the petition, where have you, this contention has been made?
It starts at my lord, para 34 I have stated and 35, my lord. I'll read from para 35, my lord. That is stated the private respondent has lodged a complaint under section against the petitioner under section
35,
35, my lord.
okay,
34 I have stated the facts, my lord. That 35.
okay.
That it is stated that the petitioner, private respondents had lodged a complaint against the petitioners under section 164 BNSS. As such, no action could have been initiated without satisfying the essential ingredients necessary for invoking the said section. That the petitioners most respectfully submit that the section 164 BNSS is a statutory provision meant to maintain public order and peace by empowering the executive magistrate to take preventive measures in case of apprehension of breach of public peace on account of dispute as to actual possession. Because it doesn't, it is only about the possession, my lord knows. as such, it emerges from the statutory provision that the
Just a minute,
consent present
what was the last sentence? Okay, the executive magistrate, while exercising under 164 CRPC,
BNSS 160.
sorry, BNSS. Can take preventive measures in case of apprehension of breach of public peace. However, cannot pass any preventive order. No, punitive order, huh? Or direct. To implement the decision of direct to implement any decision. And by issuing the impugn order, the respondent executive magistrate has exceeded his jurisdiction. Okay. Issue notice. Call for the record. Stop the petitioner shall take steps for notice upon the respondent by speed post as well as by usual process within a week from today. Stop at para. Having considered the contention made and the submission, the contention made in the petition and the submission of the counsel for the petition, it is provided that the operation of the impugn order dated. The last order should be stayed or what? Which one?
My lord,
14/10/2025.
my lord, 14/7 and 14/10.
14/7 is same direction.
My lord, 14/7 direction, and then 14/10 it says directing the police to
Okay.
victim.
The operation of the order dated 14/7/2025 issued by the additional deputy commissioner and the order dated 14/10/2025 issued by the additional deputy commissioner Anjo. Shall
More specifically, sorry, my lord, it's ADC Hawiliang, man. Hawiliang.
ADC Hawiliang.
Yes, Hawiliang.
Okay, issued by ADC Hawiliang, additional deputy commissioner Hawiliang. Shall remain state to the extent what is the specific which one is to be stayed?
Man,
To the extent that it directed to implement.
Malo, if Malo says Malo stay Malo, that will suffice otherwise.
Till the next returnable date, huh? No, so then, by maintaining a status quo over the alleged disputed lane, okay,
Man,
till the next returnable date. And then I'll have to also clarify that this is not deciding the title, and
man.
it is made clear that
It doesn't Malo says so, but what my submission basically is, there is no likelihood of breach of this. High Court says, our court, Supreme Court, everyone says
that,
breach of
this
peace
court
cannot be
is
the
not,
mental peace.
not making any observation against the right title of the lane. And the petitioner shall not make any change over the alleged disputed lane. Okay,
Just one prayer.
list this matter after
So 4 weeks, Malo.
4 weeks. Okay.
Malo, just change is in Malo. We are just constructing OBT house, man.
It is status quo.
My lord.
Status quo, and then in the beside that, what I'm saying is you cannot change it now.
My lord.
But here, what I found is probably you may have to challenge all those, and then probably you may have to approach the civil court for title, because they have already decided. I do not know what is the effect of those order passed by the district level under the
Right.
Forest Act. And then this title need to be decided.
Right.
And unless you challenge all those, otherwise it will be difficult.
Yes, my lord, I have put to challenge also the manner in which, because the act.
The manner that is fine, but then the title itself is with them only now. It appears. Okay.
No, my lord, the
No.
order of the DC also, and deeply obliged.
Yes.
Item number 6.
Yes.
This matter, Malata, so far I have not received any instruction. So, Malata, may I pray that Malata, some more time may be given to Malata file appropriate
Okay.
Malata affidavit in opposition on behalf of Indian
Mr.
Railway.
Bamlani Council for the petitioner is present. Mr. M. Kato, Lanet DSTI.
Lordship, as a last opportunity, Lordship, since this case has been pending since 2022.
Submitted. He is yet to receive an instruction in this regard. And therefore pray for some more time to obtain necessary instruction so as to enable him to file affidavit in opposition. The prayer is allowed. No, why should we last?
Since your Lord several occasions.
We file by next time?
Yes.
Okay. Next time we'll pass such order. Okay, sir. The prayer is allowed. List this matter after 4 weeks.
Deeply.
Obliged. Item number 9.
Yes.
And on behalf of Mr. T. Thakur, standing counsel for the head.
You are for respondent.
Yes,
Okay, none appears on behalf of the petitioner on call. However, Mr.
Eltika.
You are appearing for the first time here after filing Wakalat Nama.
No, I'm on
You
behalf
have
of
earlier also appeared.
I'm on behalf of T. Thakur.
Mr.
T. Thakur.
Your good name
Eltika.
appear on behalf of Mr. T.
T. Thakur.
Tagum. Tagum is for respondent number.
Education.
Oh, Lanet Standing Counsel for the Education Department. In absence of the petitioner, the matter stands adjourned. Just a minute, sir. Okay. discharge matter after 3 weeks. Okay.
Item number 10,
May I please, Lordship?
Yes.
Lordship, the petitioner before your Lordship, by filing this I application, seeking for a small modification, alteration of the interim bail order passed by this honorable court, Lordship. Lordship, before coming into that fact, I would like to narrate a few small fact background of the case.
What is the condition that you want?
Condition number 4, Lordship, whereby my Lordship has directed.
What is the problem with that?
Problem, Your Honor? There is a direction that the accused person shall not leave the jurisdiction of the state of Arunachal Pradesh
Yes. we
without
should not
seeking prior permission.
without
from-
information.
Yes.
Hmm.
For that, Lordship, the accused person went to the learned CGM,
Mhm.
Dafureja, filed an application for permission to leave his, because he is native of Jorhat and his mother,
What he is doing here in Arunachal Pradesh?
he is not doing here, Lordship. That is the problem.
But he is staying here.
No, Lordship. That is the problem. But because of that order only, he was staying at hotel.
Can be changed. That can be. Because it was, but what is the status of the case now?
Investigation is.
Investigation
Yeah.
still.
In fact, accused person and the complainant had already settled, Your Honor. It was amount for non-payment of bad tax of 4 crore. It was already paid between the main accused person
Okay.
and the
Ah,
complainant.
Mr. K. Lolen, Land Council for that. You have any objection? It's only change.
no, yes, sir, but as and when called for IO,
Okay.
That order is already there, Your Honor.
Council
IO
for- Land
or
Council for
court.
the applicant. There also heard Mr. Jitado, Land additional PP for the state staff. By an order dated. Which is the order, where the this condition
4925, Lordship.
page?
Page number, Lordship, is 47. It starts from 45 and operative person, Lordship.
37.
Lordship, 37. I'm extremely sorry, Lordship. No, 44. 44 is the close,
Okay, by an order dated
4/9/2025.
4/9/2025. The petitioner, the applicant petitioner was granted interim anticipatory bail with certain condition, along with the condition that, and along with the condition number 4,
Yes,
that the accused applicant shall not leave the state of Arunachal Pradesh without prior permission from the concerned jurisdictional court.
yes.
By subsequent order dated 12/9/2025, the interim anticipatory bail granted to the accused, granted to the applicant
Was made
Was-
absolute.
made absolute with the same terms and conditions.
Yes.
It is submitted that the applicant is a resident of Jorhat
Jorhat, Assam.
and he needs to be there for his mother's treatment.
Yes.
Vishwakumar and according made an application before the learned Chief Judicial Magistrate and on application being made, the learned Chief Judicial Magistrate had granted 20 days time to enable him to go outside for his mother's treatment. And on expiry of 20 days, he was directed to report back on 16/10/2025. This, sir, the council, land council for the petitioner submits that such, due to the above condition, the petition, the applicant is in extreme hardship to go out from the state of Arunachal Pradesh. Therefore, Arunachal Pradesh, stop, there. By filing this application, by filing this interlocutory application, the applicant seeks modification of the condition number 4 of the bail order and prays for bail order stuff, to enable him to go out of the state of Arunachal Pradesh. Staff, the Dani Edison PP has no objection provided the petition applicant is directed to cooperate and appear before the IO of the case as and when called for. Staff, in view of the above, this application is allowed. In view of the above, this court is of the view that the suitable modification is called for. The modification of the condition number 4 is called for. Stop. Accordingly, the condition number, accordingly, the condition number 4 of the bail application, bail order dated
4/9/25,
4/9/25 and
12/9/25.
12/9/25. No, earlier order.
First order interim was passed on 4/9, Lordship,
Okay, 4/9/25 and 12/9/25
passed in AB number 121 of
in AB number 121,
1. Yes, Lordship.
stroke 2025. And the applicant petitioner is granted liberty to go out of his station. Is at liberty to go out of his station. However, on the condition that he provide his present address at Assam and also his telephone mobile number to the IO and appear before him as and when called for.
Lordship.
Okay.
Lordship.
With the above, this IO stands allowed and disposed of. Okay.
Quickly obliged. Accordingly modified. Never like.